Welcome to the Business Bites Podcast, the podcast for busy entrepreneurs. Whether you're an online entrepreneur or seeking after brick and mortar success, this podcast brings you quick bites of content so you can learn and grow anywhere you are. Now here's your host, Rachel Brainke.
Hey guys, my name is Rachel Brainke and I am joined with Autumn Boyd, and we're going to share with you guys a little bit about U.S. copyright and trademark law for entrepreneurs. Autumn and I are excited to share this because we see so many of you guys falling into legal traps, and we would rather you focus on your business, growing it, making money, and living life, as opposed to having to worry about the legal stuff. Our goal is for you guys to be educated, prevent issues, put the things in play that you need to put into play, but we're going to break it down nice and easy for you so you can implement it easily to focus on everything I just outlined. I am an attorney, just like Autumn. We both do intellectual property work. I am very specific in the areas of fitness professionals, photographers, and other creatives. And I'll let Autumn introduce herself here in a second. But just from a personal side note from me, I am a mother, a triathlete, and I have 5 kids, and I am a wife as well. So everything that I recommend is not just from a legal perspective. I have other businesses outside of running a law firm and practicing law. So guys, I'm in the trenches just like you. I understand the pain points. I didn't come out the gate in entrepreneurship knowing all this. I just got the benefit of becoming a lawyer later, if you want to call that a benefit. And so whenever the advice or the comments and recommendations that I make is pairing the legal stuff with also the real life application. So just understand, take a deep breath through this. We are where you guys are now, but we're hoping to guide you a little bit. Autumn?
Yay! Well, I'm so excited to be here with Rachel. As she mentioned, I am also a lawyer. My background is copyright and trademark. I've also worked with a lot of photographers, so we have that in common as well. And our law firm specializes in helping online and e-commerce entrepreneurs. So we handle not just intellectual property, but all the business stuff that, most of us, just like Rachel said, did not go to business school. So we are learning it as we go. And my goal when I work with clients is really to help them learn about things that will be coming up as they grow and scale. We call that issue spotting when we're lawyers, but you don't need to know all this legal stuff, but we want to give you at least enough of a vocabulary and kind of a really high level overview is what we're going to be talking about today, so that when these issues come up, and they will come up for every business, but especially if you're in a digital business or a creative business, like Rachel said, you are going to be having to deal with copyrights and trademarks. So it's important that you at least understand kind of how they work and when to call in an expert. So we are going to go over especially some copyright concepts today. I feel like we hear a lot more about trademarks, but copyright can be really important for a creative business as well.
And there's a lot of misinformation for copyright out there. So we're going to try to clear out those myths for you. And if you're watching this and you're not sure if it really applies because you're like, copyrights, intellectual property, if you're in business, you have intellectual property. You have a business name. You probably have a logo. You have blog posts, social media posts, images, videos. Pretty much anything that you're using in marketing. On the photographer side, you're selling intellectual property or licensing it rather. But if you're maybe in a field you're going, I don't really know, I don't really understand. Trust me, guaranteed, probably 99.9999% of you have intellectual property. If you don't have any of the things that I listed, you probably will eventually, or maybe you're not an entrepreneur and you're just watching because you want to learn the legal stuff, which is super cool as well. A disclaimer is Autumn and I are United States-based attorneys, so this is going to be for U.S.-based businesses, and it's not legal advice. This is more general information. One of the benefits of copyright and trademark is that it is fairly federal. So you guys are going to find that across the United States, it's going to be pretty much the same information. Just don't hang your hat on everything we said. Really, it's all about equipping you, like Autumn said, knowing the lingo, the vocabulary, so that you can research more. And also when you do have to go talk to an attorney, and hopefully that it is before an issue happens and not when one happens, because it will. So you can walk in the door and be empowered with the knowledge and empowered with the decision making, and not just blindly handing over what your intellectual property and your whole livelihood to an attorney. So just know that, again, this is general information, pretty going to be spot on. We do this all day, every day, but don't hang your hat on it as legal advice because all situations can be different. We're going to speak generally. We're probably going to get some examples that can help you to kind of better understand how to apply all of this. But just know at the end of the day, you need to talk to a local attorney before you guys go out to try to do it yourself. We're going to define copyright and trademark and all that. My added disclaimer for this is I think you're going to feel pretty confident when you're done listening about the topics, but doing it yourself can cost you a lot more money when you have to clean it up later. I really, again, this information so you're equipped, not so much that you can implement. Lawyers are worth their weight in gold. We get a bad rap. There's a lot of jokes about us, but really, I hate when new entrepreneurs come to me, especially if you're in the new beginnings of your business and you're like, oh, I have a copyright issue and I don't really have the money for an attorney. And it costs a lot if you've infringed somebody, which we're going to talk about, or if someone's infringing you, it costs money for you to be able to fix those issues. And it just breaks my heart when I see these business owners struggling with, well, I want to do the right thing or I want to enforce my rights, but don't really have the funds. So I guess my other little FYI with that is start saving now. If you don't have a line item in your budget for legal services and tax services as
here's
well.
My praise hands for this.
Right. Yeah, Autumn and I, we've had these conversations before because we work with you guys. We get it. We've been there. So right now, scribble down, piece of paper, line item to start saving. Even if you just put maybe $100 away every month, that's $1,200 at the end of the year. And you may never have to use it, but by the end, I think we'll have you convinced that you at least want to get a consult with a local attorney and kind of see what your rights and protections are. So Autumn, do you want to go ahead? Do you have anything else on that or do you want to kick off on copyright?
Yeah, let's kick off on copyright. The only thing I would add is just like you, I think it should be a line item in every budget. It really is. Legal is a cost of doing business. So it needs to be something just like marketing or paying your employees to actually do the thing. It needs to be something that you are budgeting for every single year. And like Rachel said, maybe not every year do you have to use it all, but at some point, if you're in business, you're going to have a dispute, you're going to have a contract that goes wrong, you're going to have an intellectual property issue. So definitely something to plan ahead for. But yeah, let's dive into just kind of we're going to be using the words copyright and trademark, and there's a lot of confusion about even what those are. So just at a really high level, and again, this is all based on U.S. law. In the U.S., copyright law is going to protect what we call original works of authorship. So these are things we think of as creative works: photos, music, books, movies, sculpture. But it can also be things in your business like if you have a manual that has a bunch of writing in it. It can be if you sell an online course, most of that content is probably going to be protected by copyright. If you're doing videos like this one, this is protected by copyright. So it's not going to protect facts or ideas. That is a big misconception. Someone comes to me and they say, I have this great idea for a system of how to do XYZ, or I want to make a movie about, and they'll kind of give me a very high level outline of a story. And you can't protect an idea. You can't stop somebody else from basically doing the same idea, but it will protect the way that you actually express that. So what that means is if you actually make the movie, it will protect the movie. If you actually write it down in a book, it will protect the book. It will protect the way you put your idea kind of into a creative work. And
the way I look at it, is it tangible or intangible? Can I hold it? Can I physically see the text on the screen, or is it still up here? It needs to be tangible and fixed.
Yeah, I say it needs to come out of your brain. And it can be in a computer file, but it can't just be in your brain. It has to be somewhere. Right. Yeah. So I would love for you, Rachel, to go over how trademark is a little bit different than copyright.
Yeah, we'll dig into a little bit more of trademark. The thing with copyright is that you're inherently protecting that tangible work of authorship. A trademark is more protecting a source indicator. And I always think of it like a string. You're connecting let's think of a big brand, Coca-Cola, right? Their name is trademarked. And that's some of the examples I'll go over here in a second of what you can trademark. But when you see a Coke can, put a string on it and, string it over to the Coca-Cola headquarters in Atlanta or wherever, that it's coming from Coca-Cola. If they're using that mark, they get to preserve and save and protect that as a source indicator. Nike swoosh is another big one. If you buy a Nike swoosh, that it should be coming from Nike. And so we'll dig in a little bit more on trademarks of that, but just keep in mind that copyright the actual work itself. The trademark is protection of it as a source indicator. Now, there is overlap on that because if someone is using your logo, that's a great example. Your logo is probably an indicator, like the Nike swoosh, of your business, of where your goods and services are coming from. But also the swoosh itself inherently has copyright protectable elements to it. So it can be used together. There is an overlap. Just know they have their own distinctive, what's the word I'm looking for? Implementation.
Yeah, they're protecting different things.
Yeah, exactly.
Yeah. Great. So in the U.S., and again, this is only in the U.S. that we're talking about today.
You say that repeatedly because there'll be someone that watches it and go, well, that doesn't, I talked to my lawyer in my country and it doesn't work that way. And we're like, U.S.
Yes. So we have automatic copyright protection in the U.S. And this is another way that trademark law is a little bit different. But under our Federal Copyright Act, as soon as, like we said, it goes out of your brain and it is fixed into something tangible, whether it's a computer file or a piece of paper or a sculpture, you're automatically protected under copyright law. So that means you own the rights, whoever created it, and you have the right to keep other people from using your creative work. So you have we call these exclusive rights. So you control the work, basically, once you create it. And you'll hear us talk about infringement today. So that's something I just wanted to define. That means using something without the permission of the person who owns it. Mm-hmm. So you get this automatic protection. In the US, again, the initial owner of any copyright is going to be the person who creates it. This gets a little bit tricky when we have employees and contractors. So you may have heard about work for hire. Rachel, do you want to go over what that means?
Yeah, I think, like Autumn said, I'm the creator, I'm the photographer, or I'm the individual writing the book. I am going to have that ownership over whatever I have tangibly created. However, if I am an employee of an entity, maybe I work for somebody and I create a manual or a book, by default, that legal entity in the scope of employment, my status is actually as an employee. It's not owned by me. It's owned by my employer, by the legal entity that employs me. Now, if I'm an independent contractor, I'm more of like a 1099. I don't work for them all the time. I don't really receive benefits. And there's a whole long test you guys can check out at irs.gov. And many of the states have taken that test and kind of applied it and modified it a bit, but they're pretty much all inherently the same elements. It's kind of the sliding scale. You look at how much control does the employer have over you or not. It's not enough for you to say, I'm an independent contractor, so I own everything. By default, independent contractors own their intellectual property and the copyrights on the stuff that they create. It's not enough just to raise your hand and say, I'm an independent contractor. It's not enough for the illegal entity that is giving you this task to say you're an independent contractor if they treat you like an employee. And you guys can dig into that test. It really is, the question is how much control does that employer, does that legal entity have over you? And it's, the more control, the more likely you're going to be an employee, and the more likely whatever you create is going to be owned by that legal entity. In the inverse, if it's less control and you're an independent contractor, the independent contractor retains the ownership over that works, whatever they have created. What's really, really important about this, and a lot of people, if you've gotten a logo designed for you, you've probably hired an independent contractor.
There's so much confusion in this area, I think.
I know. And and it's, I ran into this issue when I first started out. I wasn't a lawyer. I thought I hire a one-off logo designer. I get a logo. I go to get it trademarked. But when I go to get it trademarked, or I go to enforce my copyrights because someone's then using my logo, if I'm not the owner, if I'm not the copyright holder, then the intellectual property rights owner, I can't enforce any rights. I can't even register it for copyright or trademark if I don't have the rights to do so. So in this context, if you guys have gone out to get a logo, you want to make sure, because they're probably an independent contractor, you want to make sure that they have signed over the rights.
Yes.
Through contract. And
it has to be in writing. A verbal agreement will not work here. It has to be in writing.
Yep. And the scary thing about that for me is also say you don't get it in writing, like Autumn said, and you get this logo created, you've been using it for 10 years, and all of a sudden someone else is using it and you want to try to stop them. Well, you don't have the rights to stop them. But guess what? Also, at any time, that logo designer, since they're the ones that are the actual owner of that logo, can stop you from using the logo at any time. You really have only been given a license of use. You have no ownership in it. So not only could you not enforce your rights because you don't really have any, you could also be stopped from using that if you've hired an independent contractor. So I know sometimes Autumn and I are in a couple of Facebook groups together. That's how we met. And you'll see us chime in and go, well, did you get that in writing? And it's because we're trying to protect you guys, because you want to be able to keep using your logo. You want to be able to register it. You want to be able to enforce. And you could sub logo out for image, for book, anything.
I see this a lot with photography as well, as I'm sure you do. You have a new website, you need some photos created, maybe headshots. And you think, well, I paid that photographer. I told them what to do. It's my face in the picture. Certainly I own that. And the answer is no, you don't necessarily own that unless you have gotten it in writing. So it's so critical if you are having things created for your business. A lot of us use copywriters or other contractors to help us with social media or with other kinds of marketing efforts. You probably do not own that stuff unless you have it in writing that you do.
Mm-hmm. And with owning it, I go back to law school when they taught us about the bundle of sticks.
Yes.
And each stick represents a different right. So the right to use it, distribute it, display it, create derivative works. But I take it a step further in my mind. When I have that logo designer create that logo, they're still holding that bundle of sticks. So let's say that someone takes that logo and they're using it and I want to try to enforce. My hands are empty. I have no stick to hit them over the head with, right? All those sticks have to be given to me in order for me to be able to enforce. And I don't mean go out and actually hit people over the head, but that's just kind of how I visually think about, they have to sign over and hand me that bundle of sticks for me to be able to do anything with those sticks.
It's another area where this sometimes comes up is, let's say you've been working with a designer to design a logo or other graphics for your business, and maybe you and the designer have a falling out. You don't really love the direction they're going in. And maybe you think, well, I'm not going to pay them because they haven't finished this project, but I want to take the work they've done and take it to another designer to get it finished. Unless in your contract you have the right to that work, you probably can't do that. The designer still owns all of that. And I've seen it on this flip side. I've helped designers with, contract disputes for lots and lots of money. And, they were working with a big corporation, but because of the way the contract was written, or maybe they didn't have a contract at all, the corporation may have paid them a lot of money and was left, like you said, with empty hands, no rights to anything.
We had a client, and I should have mentioned this earlier. It can even come down to website code. She had hired a brand developer. So it was like a logo, slogan, the website design, but it was also custom coding features. And so that custom coding itself was inherently protected. It was the same situation like you're talking about. They had a falling out and she wanted to take it to have someone else complete it. But our client, because she came to us after the fact, she didn't come to us before, had nothing to take. All that money, we're still working through it, but essentially all that money could be lost. So our recommendation is, if you're in these situations, just keep in mind, if you don't have that bundle of sticks, you're not the one who created it. I even recommend this when you have employees. As the legal entity, I make everyone who works for me that I do tasks with to sign a intellectual property acknowledgement that everything they create in the scope of what I provide them is going to be mine. It's going to be my legal entities. And the reason I also have employees, because I do have W-2s and then I have 1099 independent contractors. We talked about earlier with the IRS test that you can look up, to determine the less control, more control. You may have a transition. You may start with someone as an independent contractor and they may transition to employee, or in the inverse, just by mere operation of how you treat them over the years, especially when you start developing friendship and you're becoming a lot more lax. It's just harder after the fact to come and get documents signed. I have them signed all up front just so that there's no question at all to who owns that intellectual property.
That is a great idea. I'm always kind of nagging my clients about, did you get that independent contractor agreement signed? And they're like, yeah, we'll do it at some point. And then we had one recently where there was someone left and there was a little bit of bad talking about one another. And we included what we call a non-disparagement. This is not a copyright issue, but just saying, you can't trash each other in public. And she had not gotten that contract signed. And she was like, now I understand why it's so important. Like, I'm going to go get everybody to sign them right now.
Yeah. And that's the thing. You always want to, and I think this is also why lawyers get a bad rep, because we're always looking for the worst case scenarios and we have the end in mind because it will happen. And if you're working with friends, now my husband and I kind of have this rule that we don't really do business with friends, at least large business jobs. We may do some minor stuff, but if we do that, we do it clean and clear. We sign contracts, we pay money, we pay the actual rate. We don't do discounting because we want to preserve personal relationships, but also because I see it all the time that, and I'm sure you do too, Autumn, more problems actually occur when you're working with friends and family as opposed to strangers.
Yeah, absolutely. I was joking. My husband has several of his own businesses as well, and he's involved in working on a deal, and it's kind of a long-term thing. There probably won't be any money from it for a while. And the other guy's like, well, don't you trust me? Like, I'll make good on this. And I was like,
no.
I was like, A, I don't trust anyone further than I can throw them, and I'm not very strong. But B, like, yes, if you trust me, you will have no problem putting it in writing because you intend to stand up to your promises. Like, that's the way we protect everybody. That's how we show we are really trustworthy. All right.
I agree.
Yeah.
Go ahead. Let's talk about co-ownership, because I think that is a huge question, especially amongst photographers specifically.
Yeah, I think especially in creative fields, we do a lot of collaboration, which is awesome. I think we make, way better things when we are working with another creative mind. But copyright law is kind of weird when it comes to co-ownership. So the basic rule is if you're working with someone and you're both contributing something creative to it, and there is a threshold, but it's pretty low of how much each person has to contribute. It could be 99% one person and 1% the other person. You now are both co-owners. And the law does not see that one person did 99% and the other person did 1%. It kind of treats you as equals. So this is another area, and I'd love to get some of your input, Rachel, from the photography world, of how you.
I'm not a fan of co-ownership.
Well, that's what I was about to say. I just always put it in writing, and we figure it out on the front end because the way the law works is not how most people want it to work.
Mm-hmm. Mm-hmm. And I've actually run into this with having my podcast and having guests come on. By default, we just have everything signed over to us so that we can utilize it. Of course, I feel like I've also developed a rapport that the guests know that I'm not going to go and use it in a nefarious type manner. I love that word, nefarious. But at the same time, they've asked, well, but don't I have any ownership in part of the interview and what I'm developing with you? And we've just worked it out on the front end before. Again, this is why you don't wait till after.
Do you have people sign a podcast guest agreement?
I do.
Yeah, I wish more people would. Most people don't, but I think it's so smart. And I had this same question asked to me, like, does a podcast guest have ownership in that podcast episode? And I think you can make an argument that they do.
Mm-hmm. Mm-hmm. And it is easy. The thing is that if they ask, and this is where a lot of the issues run into. People confuse copyright ownership because you have that bundle of sticks and one of them is being able to distribute and use it, right? Or two sticks, actually. But you may have an issue like in the photographer client situation or with two podcast guests, like the host and a guest. They may just want to be able to use it, right? They don't have to own it to use it. Now, I know we said that's true. However, you as the owner of the work, so me as the podcast host, say all of that signed over to me. I have all those sticks. I get to extend a license to any of the guests who want to go and use it. Again, they can't do that because I own the whole thing. I could sue them for infringement if I don't give them permission, but I'm a reasonable individual. We sort this all out ahead of time. And and it all comes down to also, you got to balance it with marketing and yada, yada. But when it comes like photographer client, many times the clients are like, oh, I want all the rights. Well, they don't know the distinctions between owning it and the enforcement of that and being able to use it. Most just want to be able to print and use it on their social media. Yeah. And I've had photographer clients too who really wanted to keep all of the rights and have had disputes with their clients who want to own all the rights. And I've said to it depends on the situation, but I have said to some photographer
clients, like, why do you need all the rights? Why can't you sign them over? Maybe charge a little more. If you're doing a catalog shoot for a product, the idea, if you want to hold on to the rights, is maybe you could reuse them somewhere else, or you could license them to somebody else. But if you're doing a product photo shoot, you're not probably going to license those to anyone else. And so it's probably not a big deal for you to sign over the rights. So it's going to depend on the situation, what is important to you, what makes sense, and your relationship with the person you're working with, for sure.
For sure. So yeah, coming down to co-ownership, like you said, put it all in writing. There's not a threshold necessarily of how much someone has to contribute. I'm just not a fan of it, because what happens if there is infringement that occurs on it? Then you're just, I don't know, you've got a ball and chain that you've got to deal with.
Yeah.
I'm just not a fan. I feel like you could come up with one person owning and the other having a very good extended perpetual license of use without having to have ownership.
Yeah, and a profit share or something like that. Like if you're truly collaborating on something, you can work out the money without having to have ownership.
Yeah, exactly.
Yeah.
Good call.
All right, so let's talk about registration. I think there is so much confusion about this area because we do have this weird situation in the US where you have automatic protection, but unless you register, you can't actually enforce those rights. So tell me what you see as some of the benefits to registering. Do you encourage registration or only in certain scenarios? I am personally a copyright evangelist, so I'm always trying to tell people to register.
Yes. So yeah, like Autumn said, copyright by default, once you create it and it's published, you have copyright protections. Now, that's just simply being able to say, I have copyright protections. There's no actual written in law benefits like taking the step of registration will give you. When it comes to, I created a logo or I created an image, I didn't register it. Yeah, I can send a demand letter, I can sue someone for infringement, but my damages are going to be based on actual damages. So how was I damaged? How much money did that person make through the use of that intellectual property item? In the inverse, if you take the step to register, which is so super cheap, you spend more money on a 2-steak meal at Outback, right? And you just stick it into your cost of doing business. You can have, what are the numbers? I know you can get statutory attorney's fees. And what's the numbers?
It's up to $150,000 per work. So let's say you took 5 photos, somebody took 5 of your photos, that's 5 times $150,000. So and if you're trying to prove actual damages, you're probably looking at maybe a couple $1,000s, best case scenario, and it's going to cost you more than that to hire a lawyer to file a lawsuit. So you all of a sudden go from something that's really not even worth the cost to enforce to, okay, now we're talking real money and I can make the other side pay for my attorney. So now it makes it more likely that you'll be able to get an attorney interested in actually helping you because they know they might be able to get paid on the back end as part of your damages.
Yeah. Well, and that's maybe a side note on that. A lot of copyright lawyers will do contingency based only, but most of them will only do contingency based if you have an actual, if you have a registration.
Yes.
We do things a little bit differently. We don't just jump to filing lawsuits. I was talking about this with my partner yesterday. I don't think we've ever jumped in a copyright infringement case to just filing off the bat. We at least start with one letter.
Yeah.
And so we just charge hourly. For sure. And, especially in this world where many of you listening probably know way more than the majority of people out there now, they just don't know. That's not a defense of the law, but it definitely, sometimes it's just a little education and just outlining your rights goes a long way. And we even do that when you have unregistered copyrights as well. You still can assert to request payment, to request people to take it down. But anyways, we'll talk about it here in a little bit. I am a huge proponent of registration for, if nothing else, just to make sure that $150,000 number, it's a really good
it's like a hammer when you're negotiating.
Yes, because if you have unregistered, and I've run into this with a couple of clients, the infringing party will then say, well, what do you typically charge for that? That type of conversation doesn't really happen when you have registration because the $150,000, not just 150, the 150,000 already put into the law for you. So that's an anchoring point for you already.
Yeah. That's awesome. I also like it, especially if you have a business where you're doing licensing. So if you're giving other people permission to use your work and they're paying you, that makes that license more valuable because, again, if somebody rips them off, they know that it's going to be protectable and that you can take action. So it kind of protects them if you're in a licensing type scenario. The Copyright Office database is not great, but it is searchable. They're actually working on this. And I talked with a woman recently who's like doing their revamp. I don't know when it's going to go live, but they are working on it. It's very difficult to search for visual things. Like, let's say, someone took a photo of a horse and you don't know if it's registered. There's pretty much no way to search for an image. But if like the title of a book or the title, the name of a company and you want to see like, have they registered anything? You can do some basic searching. So it puts people on notice that you believe that you have rights, you take them seriously. It's likely to get other people to take you more seriously.
And, if you are going to end up going to file a federal lawsuit because you're going to be in federal court, you're going to have to register anyways.
Yes.
So even if which I hate this conversation with clients. Yeah, it's required before you even file. But what will happen, we'll run into is we'll go through letter writing. It may not pan out. And then it's an unregistered image and they'll say, okay, let's sue. And I go, well, we have to register. Now they're faced with, okay, do I wait 6 to 9 months for that registration to be approved? Or do I pay the $800 expedited fee for this registration? And so it just especially when you are a small business, maybe a solo typepreneur, you don't necessarily have an extra $800 on top of legal fees. So for me, I just recommend, yes, registration for all the reasons that we've listed. Stick it into your regular workflow. Like we're going to talk about with infringement, for your registration to have the full force, if it's $150,000, the attorney's fees and everything, you need to register within 90 days of creation/publication. And I say it that way because there's still a little bit of a gray area of really what defines publication. Yeah. And so 90 days for when that happens with the work and before the infringing action occurs. There is a little caveat if they keep infringing, but they do it in a different manner after registration.
It's really difficult. Yeah.
It's just too confusing to go down that path, but just know that you're not completely excluded. Ask your lawyer.
So let's talk about the registration process. It is online. There are paper forms. Do not use the paper forms. It will make it go slower.
They charge you more. Yeah.
Yes. It's more expensive and slower. I think the system, it's not incredibly user-friendly, but it's fairly simple. It's definitely something that maybe talk with a lawyer the first time you file a registration. Make sure you're filling in all the blanks the right way. That's what I do with a lot of my clients. We'll do one together and then they can take it over because it is expensive to have a lawyer doing all your registrations, and it's a pretty user-friendly system.
Mm-hmm. Yeah, we've had to clean up a couple of issues that ended up in an infringement suit because they had DIY the application process. But we did just like you. We walked through and said, okay, from now on, this is what you want to do. But yeah, we did have to clean up a couple of issues. So
yeah. And the filing fees, it's going to be $35 if it's one work and you're an individual. It's $55 if it's a corporate owner. So they're pretty low. It's not nearly as expensive as the trademark process. So
for sure.
Highly recommend, like you said, just putting it into your workflow. If you're producing something new, just go ahead and get it registered.
Yep. And keep in mind, like we talked about earlier, if say you have a logo, you're going to, if you want to fully protect it, you're going to need to do a copyright registration and a trademark registration. Because again, the trademark is only protecting that string that's connecting as a source indicator for the use of that. It's not inherently protecting the actual design of the logo.
It's only if you were confusing someone.
Yep.
With a copyright, you can have someone who's not confusing your customers. They just ripped you off.
Yeah.
So
there's
kind of two different ways to protect what you've got. And it's,
no, go ahead.
Yeah. Just for a creative work like that, where it is a logo, I think doing both is definitely the best case scenario.
I agree. It's a low cost investment. It's relatively easy for you guys to do. And one of the things that's different with copyright versus trademark is that there's not a requirement to police your copyright. So let's say you find someone using your logo and you're like, oh, I just can't afford to enforce my rights on this. I'm going to let it go. You don't have a potential of losing your copyright. Whereas on the trademark side, you have a duty to reach out to the people using your trademark in a source indicator fashion. You have a duty to make sure they stop doing it, or you could potentially lose your trademark. So just know that copyright, we really do.
There's a lot of benefits.
There's a lot of benefits, and it kind of sucks that you have to come up with the investment to enforce your rights, but there's so many low cost ways and so many benefits to it that you really can help yourself just by registering. And it's like 35 bucks.
Yeah. So let's talk about the C in a circle symbol. This is another area I get a lot of questions about. So when is that appropriate to use? When should you use it? Do you have to use it?
No, you go for it.
Sure. So you do not have to have a registration to use the C in a circle. So that is the best part. It really is just meant to put other people on notice. Like, hey, I own this thing. I take my rights seriously. And you can include, you don't have to, but it's a good idea, the year that you first published the work and your name or, whoever the owner is. So that if someone sees that on a work, they know who to contact maybe if they want to use it. Or you could put something on there, again, not required, but a good idea, something like all rights reserved or, no copying without permission, however you want people to either use or not use the work. Or some people say, maybe use for personal use only. There's lots of different notices that you can include there. It used to be required that you include a copyright notice, but since the late 80s, it is not anymore. So again, this is it's a best practice. Again, different from trademark law. The R in a circle you can only use if you have a registration. Mm-hmm. But in the copyright world, the C in a circle is free for you to use, and it's a good idea.
And I definitely highly recommend doing it because from a lawyer's perspective, if someone's infringing upon you, one of the things that we can identify is that it was willful infringement. Like Autumn said, someone's then put on notice if there's a C or a circle, or like say you have a photograph and you put a watermark on it. It doesn't even have to be the C of the circle, but then they remove the watermark. That shows willfulness, that they can't use what's called an innocent infringer defense, which I still think is complete crap. But
they can't say, I had no idea this was protected by copyright. Right.
Well, and that defense is crap to me, which is like such a legal term that I'm using that. But, it drives me crazy when people use it. But when we can find that they cropped out a logo or they removed it with Photoshop or they're at the bottom of your website had the copyright or those sorts of things, it's easier and it's easier for us when we're trying to enforce your rights to say, well, you knew, it's like when your kids steal the candy before dinner and then they're like, oh, I didn't know. And you're like, I told you. Yeah,
I see your red all over your face. Yes.
I know. And you're like, I told you, they can't say, well, I didn't know. Yeah. They can try, but in a court, the judge is going to go, mm-hmm.
Yeah. It just makes your case stronger if you ever have to go after anyone. So let's talk about that. So if you find that someone has copied your stuff and it's incredibly upsetting, it is like a dagger to the heart, it's like someone has stolen your baby, what do you do? What are some of the first steps that you recommend?
Well, one thing I think is we need to identify what is infringement. Basically, we need to look and see, do they own it? Do they have a license to use it? The answer is probably no and no. And then are they using it on a commercial-based feed? I don't want to go down the path of all the
social media
fair use exceptions and all of that, media, schools. I don't want to go down that far. So just ask yourself the questions. Are they the owner? No, because it's probably your logo. Do they have a license? No, because you probably didn't give it to them. Are they using it on like a commercial-based website or a feed or a printed book? Yes. Okay, we've got infringement. From there is when you have to figure out what your next steps are going to be. I think half the battle is identifying that it is infringement. And this is where I always tell clients, and I see it in Facebook groups all the time. They're like, oh, let me just run over and get the takedown notice through the Facebook submitted. And I'm like, stop. You need to take a breath and you need to document everything. And I actually would say talk to a lawyer before you even do that, especially if it's an extremely large company that has done it.
Yeah, but or they're making money from it. Yeah,
exactly. Because once that evidence is gone, what am I going to attach to a lawsuit?
Yeah, once you reach out to them, it might disappear. So that first step is definitely take your screenshots, maybe buy the item or do whatever you need to do so that you've got your evidence of what actually happened.
And I also am not a proponent of sending an internet mob. Because if you start tipping off the company that's using it and you start ticking them off, they're going to be less likely to negotiate with you, less likely to settle, and you are going to end up having to pay more out to enforce it. Now, that being said, there have been situations where none of the legal options have panned out. That I've seen people take that, but it's like a last step.
And you mean like posting on social media and saying this company is terrible, look what they did. Yeah. Yeah. I definitely agree.
Don't do any of that yet, because we're going to walk you through now what to actually do.
So before we get to that, I want to talk about too, I get a lot of questions where it's not a photo that's been taken, the entire photo. It's maybe someone has a website and it kind of looks like my website, or someone has a logo and it's similar to my logo. So how can you tell, what is too close? It is super gray. That's the answer. It's a super gray area.
It's so arbitrary.
Yeah.
Because there's a lot of elements out there that are not protectable separately, in a logo, but the combination of them may be protectable.
Right.
So we see this a lot, especially, maybe it's something we should have said earlier. We see this a lot when people log on to Etsy or Fiverr to get pre-made logos. Those are not going to be original works. They're not inherent. More than likely, there's a bunch of them out there that are substantially
really similar. Yeah.
You're not going to get protectability over it. At least for copyright. You might for trademark, but just keeping in mind original works. And what was your question? I think I forgot now.
So just how close is too close? If someone has not really taken your work, but has maybe created their own thing that is similar, I would say that's really hard. I mean, in my experience, that's really hard to stop.
It's very hard.
Under copyright law, it's not unless it's what we call a verbatim copy, where it's pretty much they took your whole thing. You've got to show that it's substantially similar, and one judge may say yes, another judge may say no. It's a very gray area.
Yeah, it's really hard. I have an article on it, and I can't remember what the case name specifically is, but someone had taken another's work and they had tried to duplicate it, not physically duplicate it, but recreate it for themselves. And looking at it, you may think that it was from the same. Again, we're not worried about source connectors here when we're talking about copyright. You would have thought that it was from the same artist, but they even dug down into looking at the shadows from the buildings, into the reflections in the puddles, and it was very similar to me. Like you said, it's a very hard situation. I think the more clear cut is when they take your actual image or your actual logo, video, music, whatever, and use it. Is pretty clear-cut infringement.
Yeah. So let's say you do have a clear-cut infringement and you want to go after them. I always, like you said, start with a friendly request. I if it's my client, I like for them to talk to me first so we can evaluate it because you always want to think if what I send goes in front of a judge, am I going to be proud of this? Or am I
100%.
going, if I'm shown this in a deposition on the record under oath, how am I going to talk about this? So think about that. You don't want to say anything that could be used against you later, for sure. But I think a friendly request is often a good starting point.
I agree. And another thing to consider with that too is, and I get it. As an entrepreneur, I completely understand you're thinking, I could send a letter for free without a lawyer and, it could resolve itself and that would be great. The problem is you could have them clam up. They become defensive. They take it down. We don't have evidence. Or you can say and do some things that are damaging that when the lawyer gets involved, it's going to cost you more money on the lawyer because then we're spending more time trying to negotiate and tear down and repair the walls that you've now, done to the other side. I can't express to you. That's probably where the bulk of some of the issues comes into this is just really fixing interpersonally things that have been done. And it's just, to me, it's kind of a waste of money for you guys. And it's something that you could have just stopped and been like, okay, I don't need to. And I get it. When someone takes your image, especially if you're in the image or your kids are in it, you're pissed. You want to say something right then. You really have to screenshot, store it all, and then email one of us.
That's right. Quick consult on what you need to do next. Yeah. So then let's say you do get involved. What are some of the other steps that you might take to kind of escalate things, Rachel? If that friendly request, they come back and they're like, no,
they tell you to pound sand.
Yeah. Or just don't respond or.
I hate
that. That's the most frustrating.
Well, the thing is, I've gotten to the point in my practice that if they just don't respond and I know they've received it, I always try to give people the benefit of the doubt.
Yeah.
Make sure they've received it, been certified a letter, I've done all of that. If they just don't do a response, your only option is pretty much to file a lawsuit. If they do respond, but they kind of stonewall, it really depends on the situation. I had one client where it's so funny because and maybe this is a good little PSA. You guys from listening to this now know more than some attorneys that are often across the table from us because someone will get a takedown notice or, a cease and desist, and they'll run to the regular lawyer who's not an intellectual property attorney. And I've had other attorneys make the excuse of, well, it was on the web, it was fair game. That's not true. And in one of these situations, they were stonewalling, and my client didn't have registered images. And that's one thing that he should have brought up, but he didn't. But they were jerks about it. They were kind of really jerks about our demands of takedown and to pay the licensing fees for the time that they, were using it. And so I finally got fed up, and with the permission of my client, I would just send another letter and increase the demand. I would send another letter. And normally in negotiations, you're going down to meet in the middle, right? But this guy really ticked me off because he didn't know what he was talking about, and my client was really irritated, and the images were still up. And so we kept increasing the demand. We got to 14 and a half times more than her original. Now, results not guaranteed, guys. And finally, I think his client was pissed at him for allowing it to get to this. And we settled at that. Of course, my client was ecstatic, right? Yeah. Especially considering she didn't have registered images. It was a hard fought battle, but that's one of the things. I will try to be as friendly, give us benefit of the doubt as much as possible. But if you keep stonewalling, and Autumn and I can tell when the opposing counsel is trying to rack up fees for you guys. And I don't play that game. Yeah. I don't allow them, especially large companies who think that they can try to bury clients. I don't know. I don't feel right taking the money from you guys when I know that this is what they're doing. And so we'll either talk about, okay, it's time to sue, or like the tactic that I just took. I've only ever done that once.
But I think a lot of business owners don't necessarily understand that just because you own a copyright, even if you have a registration, there's no like automatic enforcement mechanism. Like you are the enforcement mechanism. You have to enforce your own rights. You have to spend your own money to enforce those rights. It's a right, but you can't do anything with it unless you're willing to put your money where your mouth is. So if you're not willing to file a lawsuit, like some of this you can try and negotiate, but if you're not willing to file a lawsuit, there may come a point in your negotiations where you're just kind of at the end of the road. You've exerted as much leverage as you can. You've threatened, you have cajoled, you have, tried all the different negotiating tactics. But if you're not willing to amp it up a notch, and frankly, even if you are willing to amp it up a notch and file the lawsuit, then you're still spending more money, and it's a long negotiation because no one wants to go to trial.
Right. We've already given you guys the steps of how to do this. Put it into your line item on your budget and save, and then register so that you can potentially
you'll have that leverage
back. Right. Yep. Yeah. So that's kind of my step. We go with I really tried to do notices before I do a DMCA takedown, unless there's a really specific reason. Maybe there's minors in the image, or that's being used.
Really want it to get down quickly.
Yeah. So I try not to do the DMCA takedowns right away. I try to give the other party, I don't know, it kind of depends on the situation.
And
but
that's where like you're filing a notice with a third party, like a Facebook or a YouTube. There is a law that basically allows for those companies, because they're not creating photos, they're just hosting other people's photos. So it protects them from being sued for copyright infringement as long as they take it down when someone asks them to. So that's what, there's this whole process and procedure about it. But I'm like you, I think it's worth, reaching out at least once and saying, hey, I see this thing, I own it, you don't have permission, please take it down. If you don't, I will file this takedown notice.
And you can also send it to their internet service provider. So to whoever they're used to.
If it's on their own website. Yeah.
Their own website. Yeah. Yep. You can't take down all of Facebook.
I know. Wouldn't that be great?
That would be good. So the DMCA takedown, and you don't have to have a lawyer send one of those, but since there are requirements, because DMCA stands for the Digital Millennium Copyright Act. So there's requirements outlined in that law that in order to force like this third party, like the YouTube, Facebook, and domain providers or hosting providers, in order to force them to take it down, you have to really comply with the requirements. So I definitely, again, you don't have to have a lawyer send the DMCA, but I highly recommend. And again, that's going to a third party. When we're talking about these takedown notices, we're sending pretty much a demand letter that's going to request maybe compensation, takedown. I don't know, maybe you want to offer them to license the image, and
if
so
that's going
to go exactly. That's going to go directly to the infringer. That's going to go directly to the infringer, and then the DMCA is going to a third party.
Yeah. Well, as we're wrapping up, I don't want to end on a down note talking about infringement.
I know.
So do you have any best practices for people, let's say like for a photographer or somebody that has a lot of copyrighted works, for just kind of managing that, developing a workflow? What do you recommend?
So we're looking at the 90-day timeline.
Yeah.
This isn't a perfect formula that I'm going to give you, but this is a manageable one. If you are absolutely slammed, it's just you, and you're not able to task somebody, you're not able to carve out time, I say the first of every quarter to do all your copyright registrations. The downfall in that is you could take an image in January and your registration slot time is not for another 3 months. You could get infringement happening in February. And for that perfect balance to fall out for us to be able to get statutory damages and the attorney's fees, it needs to be before infringement. So that's not perfect. Really, if you could, as close to when you have published the image and you have sold it, and actually you don't even have to meet with your clients yet to sell it. Maybe when you're done processing the gallery, put it into your workflow. That would be ideal, is when to do it. And it honestly, I don't know.
Even once a month. Find an assistant who can help you do this once a month.
And it's easy because you don't have to do every image. You can do galleries as long as they are all connected within like the same event, like a wedding or a portrait session. You can do an entire gallery. It's cost effective, and then you just have one upload.
Yeah. Or if you're doing an online course, stick all the stuff on a hard drive and you can mail it in. It does not have to be that complicated. Once you get everything finished, package it up, send it away.
Yeah, definitely.
Photographers are a special case because they just create so many files, the quantity is so huge.
Mm-hmm. And I've had blog posts that have gone viral that I have, that I knew that they were going to be shareable to a high level, that I went ahead and have registered them, so that they're not lifted and used.
I've registered entire blogs.
Yeah.
And again, I suggest a workflow for that too. Every quarter is my kind of dream scenario.
Right.
If you've got a blog that you're making money from, if that's your bread and butter. I have had people who are making really high income off of, ads and things tied to their blog. And then you have one post that's copied and all of a sudden your traffic's going to someone else and you can have a real hit in your income. So if it's something you're making money from, it's definitely something you need to be protecting.
And, keep in mind, and this is a little tricky, but just because someone takes your image and credits you, we go back to the fundamental questions. Are they the owner, copyright owner? No. Do they have a license? Did you give them one? No. Is it on a commercial feed? Yes. That's it. You don't have to ask, was I credited or not? Because that doesn't negate infringement.
Credit does not help. Linking to your site does not help. I know, I do too. There's a lot of misconceptions about, it was posted on Facebook, so of course I can use it because they put it out there. And that is
or
not
I
true.
use the Reshare app on Regram on Instagram. It drives me crazy because I'm like, that's not permission. It's just giving you a tool to easily steal people's stuff.
I know.
So just keep in mind, guys, if you just want to be vigilant, there are systems out there. I can't remember any at the top of my head that you can, I think TinyEye is one that you can upload your images, your logos, and your stuff. And it's like a Google alert. It will crawl the web for you. Mm-hmm. Yeah. So that if you really are going to be very serious about protecting, another thing to consider too, and I know we keep mentioning photographers, but if you're a photographer, videographer, and you have individuals in the image, it's even more important for you to patrol and police this because you could have a client that image is lifted and used elsewhere. The client is going to be upset not only at the infringer, they're going to be upset at you for not helping to protect because their face is the one that's in the image and they have publicity rights, which is a whole nother conversation. But I feel like it's a duty that we definitely need to, for ourselves, protect our intellectual property, be it a podcast, blog post, logo, image. But if we're also co-creating something with another individual or we're creating stuff for a client, and we really need to take on that responsibility. So I hope that we've kind of divided out this talk between defining it all and then what to do with infringement. Sounds very scary. I know we threw around the terms lawsuit and all of that. Please go back, re-listen, ask questions if you need to. Automatize inboxes are always open to help. This is not a case of if it happens, it's going to be when it happens. The internet makes it theft of intellectual property and abuse of it really easy.
Thanks for joining Rachel on this episode of the Business Bites. For show notes, a list of recommended tools, or referenced episodes, you can find them at businessbitespodcast.com. Until next time.